Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, January 29th, 2026 at 9:10 in the morning. So we are starting our day this morning to hear H 733, the regulation of franchise agreements. We have our legislative counsel with us, Rick Sago, who is going to walk us through the bill. Morning, Rick.
Good morning. Rick Sagal with the Office of Legislative Counsel. So as the chair said, H 733 is an act relating to the regulation of franchise agreements. And you may remember H 205 that had been amended by the committee. H 205 previously had a provision that would regulate non-competes of franchise agreements. I believe now that it's just specific to employment agreements. So this bill, H 733, does include some non-compete language, but it's actually a much bigger franchise or franchisee regulation bill. This bill would, if it passed, would really kind of require these agreements to be a certain way between franchisors and franchisees to kind of regulate that relationship. It's also somewhat of a rerun from 6 years ago, 2020. There was a bill similar to this one. I can't remember the bill number, but this is slightly a rerun from several years ago. That bill didn't really go anywhere at the time. So if I can get started, it's a 22-page bill, not as many definitions as usual for my bills. We'll start with the bottom of page 1, defining an agreement not to compete. It's an agreement between a franchisor and a franchisee that restricts the franchisee after separating from the franchisor from operating its business in a certain geographic area for a certain period of time, or in any other way that significantly impacts the ability of the franchisee to compete with the franchisor. This is an exact copy of the language in 205 as it pertained to franchisors, franchisees. An agreement not to compete does not include an agreement that prohibits the disclosure of trade secrets or a non-disclosure agreement that protects confidential information that does not constitute a trade secret. Defining franchise, it's the brand name, trademark, or other identifying information owned and managed by a franchisor. Franchise agreement is an agreement in which a franchisor grants a franchisee the right to operate a business or to offer, sell, or distribute goods or services identified or associated with a franchisor trademark. Franchise business means a business that is being operated by a franchisee that is subject to a franchise agreement. A franchisee means a person that currently operates or formerly operated a business under a franchisor's brand name, trademark, or other identifying information pursuant to a franchise agreement. The franchisor is a person that sells the right to operate a business to a franchisee pursuant to a franchise agreement. Section 4052 sets the termination by franchisor arrangements when and how a franchisor can terminate a franchise agreement. Except as otherwise provided in this chapter, no franchisor shall terminate a franchise agreement prior to the expiration of the term, except for good cause. Except for subsection C, which lays out termination causes, good cause shall be limited to the failure of the franchisee to substantially comply with the lawful requirements imposed upon the franchisee by the agreement after being given written notice, not less than 60 days in advance of the termination, and a reasonable opportunity to cure the failure, which will not be less than 60 days after receipt of the notice of noncompliance. So giving the franchisee time to comply with what the franchisor deems to be a violation of the franchise agreement. Okay, however, C, if during the period when the agreement's in effect, if any of the following events are relevant to the franchise business, immediate notice of termination by the franchisor without an opportunity to cure shall be deemed reasonable. 1, the franchisee is the subject of an order for relief in bankruptcy or is judicially determined to be insolvent, or all or a substantial part of the assets are assigned to any creditor, or the franchisee admits the franchisee's inability to pay the franchisee's debts as they come due. The franchisee abandons the franchise business by failing to operate the business for 5 consecutive days, during which the franchisee is required to operate the business under the terms of the franchise agreement, unless there is fire, flood, earthquake, or similar causes beyond their control. If the franchisor or franchisee agree in writing to terminate, that's enough. If the franchisee makes any material misrepresentation relating to the acquisition of the franchise business, or the franchisee engages in conduct that reflects materially and unfavorably upon the operation and reputation of the franchise business, the franchisee fails for a period of 10 days after notification of noncompliance to comply with any federal, state, or local law, regulation, including health, safety, building, labor laws.
Yeah, back to 4.
Sure.
So makes material, I'm sorry. Oh, yeah, relating to acquisition, or the franchisee engages in conduct that reflects materially and unfavorably upon the operation and reputation of the franchise business. So I know that there are some franchise businesses that require you to have, they're more thinking of like Chick-fil-A, right?
Mhm.
Like I think there's like standards for moral, I might be wrong on that, but I'm pretty sure that there's like standards for morality. Is that covered in there? Not that we have a Chick-fil-A in the state of Vermont. We should if you're listening. Thoughts?
I do miss Chick-fil-A from
I know,
Texas.
it's yummy.
Um,
I also want a Buc-ee's too, so.
So to answer your question, materially and unfavorably, it is. I've been using this word a lot lately. Squishy, as far as if you are a franchisee and you say something that this is not the correct term, defamation. You say something that lowers the reputation of the business. It's got to be something pretty serious. It wouldn't just be, in the Chick-fil-A example, something anti-Christian or something, something that is against their values. But you make a point that it's not super clear what the guardrails are here. And would a franchisor be able to terminate a franchise agreement because the franchisee says something that they believe makes my business look unfavorable and reduces the reputation? Probably, possibly is my answer. Yeah.
I'm just thinking that through as in, because although for that particular, I don't even know how they run their stuff, but it just made me think of it. But if a franchisor has a specific, we all know that this is what they are.
Mhm.
And, they change materially. I feel like, so I'm just concerned that this would not allow for them to part ways. I guess, does that make, that's not.
From the franchisor standpoint,
Yeah,
well, I think it gives the franchisor pretty lead. I mean, this is so normally the agreement's the agreement, and you don't want them to terminate without cause, right? So this is giving the franchisor some cause, and the cause is that you're engaging in conduct that makes my business look really bad.
really bad. But again, we're talking about, I'm trying to think of a valid example because I just can't think of one, but there might be something that somebody does that it's not. I don't know.
It's open to interpretation to some extent, I guess is what you're grappling with, and would be open to a court or a jury to determine, was this thing that this franchisee did that reflect materially and unfavorably upon the business, the franchisor. Best way I can explain it.
Definition of unfavorably though is, I think that's where I'm concerned on, it.
Let's go.
So we talked about number 5. Number 6, the franchisee, after curing the notice of defect received in B, engages in the same noncompliance, whether or not such noncompliance is corrected in excess of 3 times per year. That would mean a automatic termination by the franchisor if they want it to be. 7, the franchisee repeatedly fails to substantially comply with the lawful requirements of the franchise agreement, whether or not corrected after notice. The franchisee or business premises of the franchisee are seized, taken over, or foreclosed by a government official in the exercise of the official's duties, or seized, taken over, or foreclosed by a creditor, etc., provided a final judgment against the franchisee remains unsatisfied for 30 days, unless a other appeal bond has been filed or a levy of execution has been made upon the license granted by the franchise agreement or upon any property used in the franchise business, and it is not discharged within 5 days following such levy. The franchisee is convicted of a felony or any other criminal misconduct that is relevant to the operation of the franchise. The franchisee fails to pay any franchise fees or other amounts due to the franchisor or its affiliate not less than 10 days after receiving written notice that such fees are overdue. The franchisor is able to meet the burden of proof that the continued operation of the franchise business by the franchisee will result in an imminent danger to the public health or safety. Section 4053, inventory after termination or non-renewal. Except as provided otherwise in the section, upon a lawful termination or non-renewal of a franchise agreement, the franchisor shall purchase from the franchisee at then current market value all inventory, supplies, equipment, fixtures, furnishings, and improvements purchased or paid for under the terms of the franchise agreement, or any ancillary or collateral agreement by the franchisee from or to the franchisor or to his approved suppliers and sources that are at the time of the notice of termination or non-renewal in the possession of the franchisee or used by the franchisee in the franchise business. The franchisor shall have the right to receive clear title to and possession of all items purchased from the franchisee pursuant to the section. The section shall not require the franchisor to purchase any personalized items or inventory, supplies, equipment, etc., that are not reasonably required to conduct the operation of the franchise business in accordance with the franchise agreement, or to which the franchisee, at the cessation of operation of the franchise business by the franchisee, cannot lawfully or does not grant the franchisor clear title and possession upon the franchisor's payment to the franchisee for the inventory, supplies, equipment, fixtures, or furnishings. This section shall not apply when the franchisee declines a bona fide offer of renewal from the franchisor, which does not include an agreement that is substantially different than the original contract. Also does not apply if the franchisor does not prevent the franchisee from retaining control of the principal place of the franchise business, to any termination or non-renewal of a franchise due to a publicly announced and non-discriminatory decision by the franchisor to completely withdraw from all franchise activity within the relevant geographic market area in which the franchise business is located. If the franchisor and franchisee mutually agree in writing to terminate or not renew the agreement, and to any inventory, supplies, equipment, fixtures, furnishings that are sold by the franchisee between the date of the notice of termination or non-renewal and the cessation of operation of the franchise business by the franchisee pursuant to the termination or non-renewal. Upon the termination or non-renewal, a franchisor may offset against the amounts owed to a franchisee under the section any amounts owed by the franchisee to the franchisor if the franchisee agrees to the amount owed or franchisor has received a final adjudication of any amounts owed. Okay. Non-renewal. Advance notice, no franchisor shall fail to renew a franchise agreement unless such franchisor provides the franchisee with written notice of its intention not to renew at least 180 days before the termination date of the agreement, and during the 180 days prior to termination of the agreement, the franchisor permits the franchisee to sell the franchisee's business to a purchaser meeting the franchisor then current requirements for granting new franchises, or if the franchisor is not granting a significant number of new franchises, then the current requirements for granting renewal franchises. Or the refusal to renew is not for the purpose of converting the franchisee's business premises to operation by employees or agents of the franchisor for such franchisor's own account, provided nothing in this subdivision or in the previous subdivision shall prohibit a franchisor from exercising a right of first refusal to purchase the franchisee's business. And termination would be permitted pursuant to section 4052. The franchisee and franchisor agree not to renew the franchise, or the franchisor withdraws from distributing its products or services through franchises in the geographic market served by the franchisee, provided the franchisor, during the period of time after giving notice pursuant to the subsection, offers such franchisee a right of first refusal of not less than 30 days of a bona fide offer made by another to purchase such franchisor's interest in such premises. In the case of the sale, transfer, assignment to another person of the franchisor's interest in one or more other controlled marketing premises, such other person in good faith offers the franchisee a franchise on substantially the same terms and conditions currently being offered by such other person to other franchisees. Or the franchisor and the franchisee fail to agree to changes or additions to the terms and conditions of the agreement if such changes or additions would result in renewal of the agreement on substantially the same terms and conditions on which the franchisor is then customarily granting renewal franchises, or if the franchisor is not then granting a significant number of renewal franchises, the terms and conditions on which the franchisor is then customarily granting new franchises. Nothing in that subsection shall prohibit a franchisor from offering or agreeing before expiration of the current franchise term to extend the term of the franchise for a limited period in order to satisfy the time of notice of non-renewal requirements of this section. By non-renewal, termination by franchisee. A franchisee may terminate a franchise agreement without penalty or fees in the event of changes to the franchise system or the competitive circumstances of the franchise business that would cause substantial negative impact or substantial financial hardship to the franchisee in the operation of the franchise business. Transfer or sale of business by franchisee. Death of the franchisee. No franchisor shall deny the surviving spouse, heirs, or estate of a deceased franchisee the opportunity to participate in the ownership of the franchise under a valid agreement for not less than 12 months after the death of the franchisee or the majority shareholder of the franchisee. During that time, the surviving spouse, heirs, or estate of this deceased, let's down for a second. During this shall either satisfy all the then current qualifications for a purchaser of a franchise business or sell, transfer, or assign the franchise to a person that satisfies the franchisor's then current standards for new franchisees. The rights granted pursuant to the section shall be granted subject to the surviving spouse, heirs, or estate of the deceased, maintaining all standards and obligations of the agreement.
Sorry. I just want to understand this part. So if the franchisee passes during the contract, the surviving spouse can run the franchise or can sell the brand. That's what this seems to me like that they have the ability to sell the franchise, but it doesn't say anything about continuing to run it, does it? Or it's not.
Participate in the ownership of the franchise under valid franchise agreement for not less than 12 months after the death. Time. So, current qualifications. So.
Gives them
So-
12 months to sell it.
Yeah, but they can also operate it during those 12 months. But then the franchisor cannot terminate. Or it sounds like even non-renew if that 12 months.
Is during that period of time.
Right. So it sounds like it gives them time to either redo the agreement, once the agreement lapses, or they can decide to sell the franchise if they choose to do that. That's my reading of it. We can discuss. It needs to be written more clearly.
I wanted to understand it. That's also my reading of it. I wonder what the franchise, will think about this, because sometimes you only give a franchise to a person who has certain skills. And if those skills are no longer as part of that franchise, that could be so I'm flagging this as a place where we could have input possible.
May I follow up on that?
So
So,
to the chair.
Don't have a lot of time.
oh, well, no, that's fine. If we don't have a lot
I
of
do
time.
have it out at 10 o'clock, so I do also need to be gone right at 10.
Just
No,
make note.
yep,
Go back to that.
she already expressed it, so it doesn't matter.
Subsection B, freedom to sell. It is unlawful for a franchisor to prevent a franchisee from selling or transferring a franchise, all or substantially all of the assets of the franchise business, or a controlling or non-controlling interest in the business to another person, provided that the person is qualified under the franchisor's then existing standards for the approval of new or renewed franchisees. These standards shall be made available and shall be applied consistently. Subdivision 2, notwithstanding what I just said, what I just read, a franchisee shall not have the right to sell, transfer, or assign the franchise all or substantially all of the assets of the franchise business, or controlling, not controlling interest without the written consent of the franchisor, except that the consent shall not be withheld unless the buyer, transferee, or assignee does not meet the standards for new or renewing franchisees as previously described, or the franchisee and the buyer, transferee, or assignee do not comply with the transfer conditions specified in the franchise agreement. This section does not prohibit a franchisor from exercising the contractual right of first refusal to purchase a franchise business, all or substantially all or controlling interest, after receipt of a bona fide offer from a proposed purchaser to purchase the franchise business, assets or interest. A franchisor exercising the contractual right of first refusal shall offer the seller payment at least equal to the value offered in a bona fide offer. This section does not require a franchisor to exercise a contractual right of first refusal. Notification of intent to sell. The franchisee, prior to the sale, assignment, or transfer of a franchise business, et cetera, to another person, notify the franchisor of the franchisee's intent to sell, transfer, or assign of the franchise business. The notice shall be in writing and delivered to the franchisor by business courier or by received mail and include all the following: the proposed transferee's name and address, a copy of all agreements related to the sale, assignment, or transfer of the franchise, the assets of the business or the interest in the franchise business, the proposed transferee's application for approval to become the successor franchisee, which shall include all forms, financial disclosures, and related information generally utilized by the franchisor in reviewing prospective new franchisees, and if those forms are readily available to or made available to the existing franchisee. If the forms are not readily available, the franchisee shall request and the franchisor shall deliver not later than 15 days after the request. As soon as practicable, after receipt of the application, the franchisor shall notify in writing the franchisee and the proposed transferee of any additional information or documentation necessary to complete the transfer. If the franchisor's then existing standards for the approval are not readily available to the franchisee, they shall deliver those standards not later than 15 days after receiving the notification. Approval or disapproval of sale. The franchisor shall not later than 60 days after receipt of all the necessary information and documentation required or as specified by written agreement between the franchisor and the franchisee, notify the franchisee of the approval or disapproval of the proposed sale, assignment, or transfer. A proposed sale, assignment, or transfer shall be deemed approved unless disapproved by the franchisor in the manner provided by the subsection. If the proposed sale, assignment, or transfer is disapproved, the franchisor shall include in the notice of disapproval a statement setting forth the reasons for the disapproval. In any action in which the franchisor's disapproval of a sale, assignment, or transfer pursuant to the section is an issue, the reasonableness of the franchisor's decision shall be a question of fact requiring consideration of all circumstances. For purposes of the subsection, the finder of fact may be an arbitrator specified in the franchise agreement or an arbitrator chosen from a list supplied by the American Arbitration Association or another impartial person. Nothing in the subsection shall prohibit summary judgment when the reasonableness of transfer approval or disapproval can be decided as a matter of law. Rights and prohibitions. The following rights and prohibitions govern the relationship between a franchisor and its franchisee. The parties shall deal with each other in good faith and in a commercially reasonable manner. A franchisor or franchisee during the sale or establishment of a franchise business shall not misrepresent or fail to disclose any of the following: the prospects or chances for success of the proposed or existing franchise business, the known total investment for such franchise business, or any effort to sell or establish more franchise locations than is reasonable to expect the market or market area for the particular franchise to sustain. It is prohibited and deemed an unfair and deceptive act or practice or an unfair method of competition and a violation of this chapter for a franchisor or an officer, agent, employee, or other representative of a franchisor to directly or indirectly do any of the following: terminate or fail to renew a franchise agreement in violation of the chapter, allow a franchise agreement to expire without complying with this chapter, fail to repurchase inventory, supplies, goods, fixtures, and equipment as required by this chapter, violate the Section 5A of the FTC Act, 15 U.S.C. 45 in connection with this business as a franchisor or an officer, agent, or other representative thereof, resort to false or misleading advertising in connection with this business as a franchisor or as an officer, agent, or other representative of a franchisor, without prior written disclosure to a franchisee, obtain vendor rebates, kickbacks, or other similar payments from another person with which the franchisee does business or that the franchisee employs on account of or in relation to the transactions between the franchisee, the franchisor, and the other person. Require a franchisee to assent to a release, assignment, novation, waiver, or estoppel that would relieve any person for any liability imposed under the chapter, including through the use of a disclaimer or checklist designed to avoid protection under the chapter. Require a franchisee to make any capital expenditure greater than $5,000 without providing a validated business case to the franchisee, showing that such expenditure has a positive return on investment for the franchisee. Require a franchisee to purchase or lease goods or services of the franchisor or from approved sources of supply, unless and to the extent that the franchisor satisfies the burden of proving that such restrictive purchasing agreements are reasonably necessary for a lawful purpose justified on business grounds, and do not substantially affect competition, provided that this subdivision does not apply to the initial inventory of the franchise. Discriminate between franchisees in the charges offered or made for goods, services, equipment, rentals, or advertising services, or in any other business dealing, unless and to the extent that the franchisor satisfies the burden of proving that any classification of or discrimination between the franchisees is reasonable based on franchises granted at materially different times, and such discrimination is reasonably related to such difference in time, or is based on other proper and justifiable distinctions considering the purposes of this chapter, and is not arbitrary, provided that nothing in the subdivision precludes negotiation of the terms and conditions of a franchise at the initiative of the franchisees. Sell, rent, or offer to sell to a franchisee any product or service for more than a fair and reasonable price. Obtain money, goods, services, anything of value, or any other benefit from any other person with which the franchisee does business on account of such business unless such benefit is disclosed to the franchisee. Restrict a franchisee from sourcing environmentally conscious products that meet required specifications or products that use environmentally conscious packaging. Or fail to make readily available to franchisees without charge true, accurate, and complete copies of all records of marketing, rewards programs, and advertising funds and fees that have been paid by franchisees, vendors, suppliers, and licensees. Franchise agreement provisions. Pricing. A franchisor shall not require a franchisee to sell any product or service for a price at a loss or otherwise not reasonably acceptable to the franchisee. Liquidated damages clauses shall not be enforceable in a case of termination of the franchise agreement by the franchisor. A default under one franchise agreement shall not in of itself constitute a default under another franchise agreement to which the franchisee or an affiliate of the franchisee is a party. No franchisor shall maintain direct or indirect control of the franchisee's employees or of the day-to-day operation of the franchise business. No renewal of a franchise agreement or a change in an operations manual or like policy shall impose a change in the hours of operation in which the franchisee deems that is unprofitable or unsafe to operate or that interferes with a religious holiday. All notices of termination or non-renewal required by this chapter shall be in writing, shall be posted by registered, certified, or other receipted mail, delivered by telegram. Is that still okay? Or personally delivered to the franchisee. Shall contain a statement of intent to terminate or not renew the franchise business together with the reasons therefor and the effective date of such termination or non-renewal or expiration. Any franchise agreement that differs from the disclosed franchise agreement shall, in totality, have negotiated terms that are to the benefit of the franchisee. Pre-dispute mandatory arbitration clauses are forbidden in a franchise agreement. A provision in a franchise agreement restricting venue to a forum outside the state is void with respect to any claim arising under or relating to a franchise agreement involving a franchise business operating within the state. No franchise agreement shall place a limitation on claims that is in conflict with existing state law. Any agreement not to compete, including an agreement not to compete contained within a contract or franchise agreement, is void and unenforceable. For existing agreements that not to compete that violate that subdivision, the franchisor must notify each franchisee that is a party to the agreement that the agreement is not to compete is void and unenforceable. Notice shall be in the form of a written individualized communication addressed to the franchisee or a former franchisee and shall be delivered to the last known address and email address of the franchisee or former franchisee. If any franchisor violates any provision of this chapter, a franchisee may bring an action against such franchisor in any court of competent jurisdiction in the state for damages sustained by the franchisee as a consequence of the franchisor's violation, together with the actual costs, including reasonable actual attorney's fees, and the franchisee may also be granted injunctive relief against unlawful termination, cancellation, non-renewal, or any other act or practice prohibited by the chapter. Notwithstanding any term or provision of a franchise agreement to the contrary, the laws of the state shall govern the interpretation of a franchise agreement of a franchise located in the state. The courts of the state and the federal courts within jurisdiction over cases filed in the state shall have exclusive jurisdiction with respect to any action brought under this chapter or any action brought by a franchisor concerning a franchise located in the state. And except as expressly provided here, nothing in the chapter shall abrogate the right of a franchisee to sue under any other law. In the event a franchisor terminates or fails to renew a franchisee in violation of the chapter, the franchisee shall be entitled to receive from the franchisor the fair market value of the franchise business and franchise assets and any other damages caused by the violation of the chapter. The franchisor may offset against any remedies a prior recovery by the franchisee and any sums owed to the franchisor or its subsidiaries by the franchisee pursuant to the franchise agreement or any ancillary agreement. And we have reached the end. The effective date is July 1, 2026.
I have a question.
Okay.
On page 20, where we have any existing agreements to non-compete. So is that legal? I'm a co-sponsor of this bill, but is it legal for us to say that you have an agreement that has a non-compete and we're now avoiding it?
So this was in the H205 language, and that came up in the H205 discussion. Can you go back in time? So generally speaking, you have the Constitution has a contracts clause, which says you cannot interfere with the right to contract. However, you can make the case that the law, even though it is a new law and it would be effective after some of these contracts, that the policy of the state is now this. And the parties agreed, and there could be litigation on this. The parties agreed when they made the contract to have a non-compete. And that would be the franchisor's stance. It's like, hey, we negotiated this. This is part of the deal. But there's nothing against the state making this the policy, saying that, no, we believe that these are, I won't use the word unconscionable, but whatever the state wants to say is that these agreements were never good in the first place. So we deem them to be not legal, even though the parties agreed to it. So to answer your question, it's gray. I'm not going to say it's unconstitutional to do this, but there would possibly be litigation. Franchisor saying that you can't.
Null contract.
And it would be nullifying, but it would certainly be, yeah.
Modifying.
Right.
Yeah, discussion for the non-compete bill was not to be retroactive.
Right. Right, that was where I thought we ended up, and I feel like this takes us thinking about school consolidation and all of the contracts that are associated, right? Like I'm curious about this on many levels.
A sort of question or a comment, which is under franchise agreement provisions. So pricing, franchise not required a franchisee to sell any product or service at a loss. My understanding is a lot of franchise agreements dictate, like often they're like vertically integrated, so the franchisor is also the supplier to the franchisee and dictates the price in which they're purchasing. So I'm not sure, it's just sort of a question about how do we capture, a franchisor can't, raise prices, and while they in the contract, they must buy the product from the franchisor, and then they have control over what price they sell it to the franchisee. So maybe there's something about market rate pricing, market rate products, or maybe maybe that covers that basically you're saying we can't sell you product so that you lose money.
Look at that last part of the sentence there, are not reasonably acceptable to the franchisee.
Yeah.
Pretty powerful for the franchisee to have that language, right? They could just say, this is not acceptable.
Yeah. And so then that would be capturing the price that the franchisor is selling product to the franchisee, because the franchisee's got to resell it, or.
Well, I can't speak to that, right? But this would just be that the franchisor saying you can't actually advertise this product for this price for whatever reason. The franchisor deems that to be, that the franchisee could say, well, this would, number one, we would suffer a loss at this price, or number two, maybe it's not acceptable for another reason. maybe there's competition in the town, and that they don't want to price it that way for whatever reason, right? So it definitely gives the franchisee some leeway to argue that we don't want to sell it at this price.
Yeah.
Yeah, and I can't speak to the market, that part of the agreement, that would be out of this
Well, and
context.
I give some quick context. I mean, I think Quiznos is what I have in mind, which was a
Sandwich shop.
sandwich shop where they overcharged franchisees for supplies. And that was, do you remember when they were all of a sudden all these Quiznos everywhere and then they all went away? It was because they couldn't make money.
So this would so make sure I understand, this does not concern that. This would be the Quiznos franchisee selling sandwiches at a certain price. Like Quiznos couldn't say you got to sell the sandwich for $10. It wouldn't be how Quiznos, the franchisor, provides the meat or bread to the franchisee. Would be you can't sell that specific.
Price, yeah.
Yeah. I don't think this bill speaks to that part of the arrangement.
Got it. Okay, thank you.
See Rep. Cooper, yeah.
This is more of a, I guess, be a stylistic query. On page 16, line 5, the word kickback is used. And is that something that ordinarily is that a statute level word?
Is that a statute level word? Well, how would you define a kickback, Rep. Cooper?
I was hoping to not be put on the spot, but I wasn't sure if that's something that is elsewhere in the statutes. Then I guess yes, but it just struck me as it caught my ear as something, and as we go through language to sort of unify it, where we're not talking about using personal pronouns, etc. I just was wondering if that was something that is a standard term. But thank you.
I think it's a pretty standard business term, a kickback, meaning you get some kind of scratch my back, scratch your back for this deal. You work with a vendor, and if you buy from this vendor, they give you some kind of discount or some kind of incentive, right? Certainly we open to further explaining that or defining that, but I think it's a pretty common business term that is used in that context.
Thank you, Rick. So we can go off live. So before we go off, just so everyone knows, we're moving down to room 11. We're meeting with House Education to John Gray from Legislative Council go over the statute for the Higher Education Endowment Trust now. So for the next hour, we'll be down in room 11. We'll be back